So again, very good evening, friends. Today we have the privilege of having with us CA Sanjay Singhal ji, who is an insolvency professional as well. He has been guiding us yesterday and day before yesterday on Supreme Court and High Court and some of the cases of NCLAT. So now we'll be taking up the cases of NCLAT and NCLT, which are covered in our syllabus. So with this, it is over to Sanjay Singhal ji. Sanjay ji, please.
Yeah, thank you, sir. Thank you, RKG. First, sir, with your permission, I may today I may take leave slight early.
No issues, sir. No issues. No issues.
But I will try to cover the most that I can.
Up to what time you will be there? 8:30 or so?
8:30, around 8:30.
Okay. No issues.
Okay. So second thing, there are 60 case lodge. Yeah. So out of which we have till yesterday we have covered 32 case lodge.
Okay, 32. Okay.
Yeah. Most of the Supreme Court and High Court case law has been covered.
Okay. Even if we are not able to cover all, then we can have another session. No issues.
Yeah.
Okay, sir. Please continue.
So, hope my screen is visible to all.
Yes, it is visible. Yes. And Sanjay ji, please share this PPT with me so that I can share with the participants.
Yes, I will definitely share, sir.
Okay.
So till yesterday we have the last case that we have discussed was State Bank of India versus Athena Energy, which was related to the personal guarantor. So next case is State Bank of India versus Matrons Limited. Basically, this case is related to the, in this case, just I will brief about the background. Mr. Shailesh Verma was a retired bank employee of the State Bank of India. He was retired from the State Bank of India. He has worked around 39 years in State Bank of India and retired on a senior position. After the retirement, he cleared the IP exam and become an RP. So the one of the case of insolvency CIRP case of Matrons Limited has been given to him by the State Bank of India. So when the corporate debtor noticed that the IRP or the RP has worked with the State Bank of India, and in the same case, State Bank of India is also a financial creditor. So he raised his objection with the NCLT that since the RP has worked with the State Bank of India around 39 years. So he's still getting the pension from the bank because he was a retired bank employee. So he was getting a pension from the bank. So he may align towards the State Bank of India while during the CIRP proceedings. So NCLT accepted the view of the corporate debtor Matrons Limited. And the SBI was not happy with the decision of the NCLT, so he approached to the NCLAT. Even NCLAT concluded that in the given set of circumstance, if you refer to the point number 5, NCLAT concluded that in the given set of circumstance, we are of the considered opinion that the apprehension of bias expressed by the corporate debtor, the appointment of Mr. Shailesh Verma as proposed IRP at the instance of appellant cannot be dismissed offhand, and the AA was perfectly justified. So NCLT has also upheld the decision of the NCLAT has also upheld the decision of the NCLT. So the matter goes with the Supreme Court. The issue before the Supreme Court is whether an IP who has been in employment with the FC can be appointed as RP. So this was the issue with the Supreme Court. So what was the decision of the Supreme Court? The Supreme Court was of the view that approach adopted by the NCLAT is not correct, that merely RP who remained in the service of the SBI and is getting pension was entitled to be the RP. So Supreme Court was of the view that you cannot raise a question on the integrity of a professional on the basis of that earlier he has worked with with the organization. And the Supreme Court, however, observed as follows: point number 2A, that the change of the RP shall not reflect adversely upon the integrity of the concerned resolution professional who has been replaced. That since the order of the NCLAT does not reflect the correct approach, the same shall not be treated as precedent. So the Supreme Court held that the order of the NCLAT does not reflect the correct approach, and same should not be taken as a precedent for the future reference. So in this case, what was happened when the matter goes to the Supreme Court, SBI changed the resolution professional. So though the matter was, since the hearing was going on, in between the RP was changed, but the still the decision has been rendered by the Supreme Court in this case. And Supreme Court, you can say, reversed the decision of the NCLAT, was not happy with the approach of the NCLAT. So this is the basically a summary of the this case. Next case is related. This is the High Court case, Dr. Vidya Sagar Garg versus IBBI. In this case, basically, Dr. Vidya Sagar has been registered, has applied for registration as a insolvency professional with IBBI. But there was an FIR was pending. FIR has been registered for against the Dr. Vidya Sagar, and that and the court proceeding were going on against that FIR. The background is Dr. Vidya Sagar has applied for registration as IP or the RP with the IBBI, but there was an FIR against Mr. Vidya Sagar, which was under process or under hearing in the in another form in court. So when the IBBI come to know about this, he reject his application. So when he file a writ petition before the High Court. So a issue before the High Court is registration as an IP if criminal proceeding are pending, whether the petitioner can be registered as an IP. So he challenged the decision of the IBBI that it is his right to be registered as IP because he has cleared the exam. Only on the mere fact that the one FIR is under process against him, he cannot be disallowed, or he cannot be registered, not allowed to register as IP. So what the decision of the High Court was, the High Court considered that the writ petition at this particular point was premature. The petitioner was given liberty to approach this court once the discharge application was disposed of by the concerned trial court. The concerned trial court was requested to take up the application for adjudication and disposal. So High Court said that High Court give the decision in favor of the IBBI. High Court said that to the petitioner, that to the Dr. Vidya Sagar, that you have approached us prematurely. First, you wait till the trial court give the decision in your FIR, and if your FIR is disposed of, then you can apply for the registration with IBBI. And the High Court, High Court asked the consent trial court to take up the application for adjudication and disposal early adjudication and disposal. So basically, what is happening nowadays? These type of questions are coming, which are related to the IBBI regulation. So they can ask the IBBI regulation, which IBBI regulation was referred in this case. So like in this case, in case of Dr. Vidya Sagar, the issue is with the regulation 6 of the IBBI regulation 2016. So that these these cases are now important and critical as well. Next two cases also related to the IBBI regulation, which is the next two cases related to the NCLAT. So this is a high court case. Next case is NCLAT. This case CAV Venkata Shivkumar versus IBBI. In this case as well, the regulation of IBBI has been challenged. CA Venkat Shivkumara, the petitioner, is a CA who has registered as an IP with the IBBI. In his writ petition, he claimed that IBBI regulation are in the violation of Article 14, 19, and 21 of the Constitution and should be overturned. The petitioner raised 3 points. The first was that Section 196 of the IBC does not authorize IBBI to levy fees based on the annual remuneration or turnover of the IP, and the registration fees of 10,000 rupees 10,000 is charged every 5 years after the certificate of registration is granted. His second contention was there is excessive delegation and therefore the regulation is liable to be struck down, because there is triple IP as well, their IBBI is there. So his contention was that there is excessive delegation. And his third argument was that because of IBBI does not provide any service to the IP, so there is no reason to charge fees as a percentage of annual remuneration or turnover. So that was his three contention on the basis of which he has filed the writ petition before the High Court. So High Court did not allow his writ petition and has held in the favor of the IBBI in this case as well. The High Court held that it is clear that Section 196 and 207 of IBC and IP regulation are intended to fulfill the IBC object and purpose in terms of IBBI operation. So if for this point number 3, IBBI does provide significant services, including those related to the intellectual property, and there is a strong correlation between the fees and the service. Given that a direct arithmetical correlation between the fee received and the service rendered is not required. So High Court said that though IBBI is providing the significant services, so and the direct correlation between the service and fees is also not required. So High Court concluded, they also concluded that IBBI is duly empowered under Section 196 and 207 of the IBC to levy fees on IP, including as a percentage of annual remuneration. So High Court said that IBC and the IBBI regulation has sufficient provision to authorize the IBBI to levy fees on annual remuneration on a percentage of annual remuneration. So the question can be asked from this case law is that, like in the case of C. Venkatraman Shivkumar, which what are the regulation which has been challenged? Which are the IBBI regulation which has been challenged in the IBBI? In the case of Shivkumar, which regulation has been challenged? So this type of question generally asked. When I give the exam, that same question came that in case of C. Venkat Shivkumar versus IBBI, which regulation of the IBBI regulation has been challenged in the High Court. So he has given the regulation number, and there were 4 regulation numbers. So we have to select one that which has to be challenged. So this case is also related to the IBBI regulation. This case is an NCLAT case. The decision was given by the NCLAT, but since just to combine all the related case at one place, I have rearranged this case here. JS and Sangrajka versus monitoring agency nominated by the COC of Arista Developer Private Limited. In this case, basically, Mr. JS was the resolution professional of Arista Developer Private Limited. So resolution plan of the Arista the Developer Private Limited has been approved by the NCLT. Resolution plan has been approved by the NCLT, and the prestigious estate project private limited was the resolution plan which has been approved by the NCLT. But there was one catch in the resolution plan. In the resolution plan, the COC has approved a success fees of ₹3 crore to the RP, and that directed the distribution thereof as well. So in the resolution plan, it was not earlier, but in the resolution plan, COC has approved the success fees. The reason behind the success fees was mentioned, given as below. That the appellant referred to various efforts undertaken as the resolution professional during the course of CIRP, such as an asset of CD worth ₹1,099 crore were handled and safeguarded. He conveyed 20 COC meeting, pursued more than 20 hearing before the NCLT and NCLAT and the Supreme Court, having different class of stakeholder, which included approx 100 financial creditor, 400 home buyers, arrange various meeting between the home buyer and resolution applicant to harmoniously resolve the issue and concern of the home buyer. Further, that the appellant got COC approval on the resolution plan. So when the matter came before the NCLAT, so this was the basically ground which has been made to justify the 3 crore success fees, that he has taken the around 20 hearing before different form. He has deal with the 20 CO. He has handled 20 COC meeting. The asset was around 1,000, more than 1,000 crore. So on the basis of this ground, the COC has approved the success fees. So the issue before the Supreme Court was whether the approval of success fees was a commercial decision of COC, and the AA could not have interfered with the same while approving the resolution plan and direct distribution of the amount set apart as a success fees. Whether success fees was chargeable by the appellant as per the IBBI regulation. So what was the decision of the NCLAT? So NCLAT held that success fees, which is more in the nature of contingency and speculative, because it's a speculative fees, if he is not part of the provision of the IBC and the regulation, and the same is not chargeable. So though I should have mentioned here the regulation as well, but in the exam, the regulation can be asked that under which regulation in the case of this case, under which regulation the success fees is and cannot be charged by the resolution professional. So NCLAT clearly held that success fees is the nature of speculative and is not part of the provision of the IBC and the regulation, and same is not chargeable. Apart from this, even if it is said to be that it is chargeable, we find that in the present matter, in the manner which it was in the last minute pushed at the time of approval of resolution plan, and the quantum are both improper and incorrect. Basically, at the last minute or in the last day, the fees was incorporated in the resolution plan. Earlier, it was not there. When the RP was appointed, it was not the part of that initial appointment letter, but it was in you can say agreed at the end of the CIRP process. So NCLAT also held that even if we assume that it is chargeable by the IBBI regulation, still it is not. Still, the manner it has been pushed in the last minute push, it is so it is not proper and correct. Further, RBI held that it was observed that success fees term is contrary to what IBBI provided in its circular dated 16th of January 2018, that insolvency resolution professional shall render service for a fees which is a reasonable reflection of his work. So NCLAT held that success fees is against the circular which has been issued by the IBBI on 16th of January 2018, which clearly say that the fees shall be reflection of the service, a reasonable reflection of the work done by the RP. The NCLAT did not find any substance and dismissed the appeal of the RP Mr. Jais. Next case is, this is a High Court case, Siri Metallic Limited versus Union of India. So in this case, the respondent is Union of India, or the. So what basically what happened in this case, when if just I say on the one day in early morning, when the director has just come to the office and enjoying his morning tea, Mr. RP came to his office and he said that, sir, I have your company has been admitted in the NCLT in CIRP process, and I am the new owner of, or the administrator of the company. So director was surprised to see that what happened. So then he came to note there was one payment was pending of some operational creditor, and he has applied to the NCLT. Basically, this case was came when this code was new. So this has happened in that case. So people who are not aware about this. So that then he raised he filed a writ petition in the High Court. So what was his argument is that, contention is that the petitioner assailed that the virus of Section 7 and relevant rules under IBC. The challenge is premised upon and resolved around the contention that the court does not afford any opportunity in a petition filed under Section 7 of the code. Basically, when the code was new, generally NCLT, what the NCLT was doing, when they saw there is a default, they passed the judgment. And people were also not aware, the companies were also not aware about the things. Even the notice came, Section 8 notice came to in front with them. Said they did not respond to that because they were not aware about the process. So the fact of the present case, the learned senior advocate for the petitioner submit that the order has been passed by the NCLT without adherence to the principle of natural justice. The respondent was not heard by the NCLT before passing the order. So the only contention of the appellant is that NCLT does not afford any principle of natural justice and passed the order without hearing the corporate debtor. This was the contention or the issue raised by the appellant in this case, Siri Metallic Limited. So what was the issue before the High Court? Whether Section 7 of the code is unconstitutional, being violative of principle of natural justice, since Section 7 does not afford any opportunity of hearing to a CD before admission of application for initiation of CIRP. So what was the decision of the High Court? So the High Court held that the High Court held that the NCLT acting under the provision of the Act, while the provision of the Companies Act, while disposing any proceeding before it is not bound by the procedure laid down under the Code of Civil Procedure. However, it is to apply the principle of natural justice in the proceeding before it. It can regulate its own procedure. So High Court is in the view that NCLT is not bound by the Code of Civil Procedure and it can regulate its own procedure. Though still High Court said that the principle of natural justice has to be followed. Again, in Section 424 of the Companies Act require that the NCLT and NCLAT to adhere to the principle of natural justice above anything else. It also allows that NCLT and NCLAT the power to regulate their own procedure. Fetter of the Code of Civil Procedure does not bind it. So the basically principle of natural justice is taken from the Code of Civil Procedure, but High Court is the view that Code of Civil Procedure does not bound NCLT or does not applicable to NCLT and NCLAT. Still, they have to follow the principle of natural justice. adherence to the principle of natural justice by the NCLT or NCLAT would note that in every situation, NCLT or NCLAT is required to afford a reasonable opportunity of hearing to the respondent before passing its order. So High Court further elaborate that it is not required that NCLT or NCLAT has to follow the principle of natural justice in every situation. If the situation is required, they can overlap the principle of natural justice, but in general, they have to follow the principle of natural justice. Like in the High Court further explain in point number 4 that in a given case, a situation may arise which may require NCLT to pass an ex parte or interim order against a respondent. Therefore, in such situation, NCLT proceed to pass an ex parte or interim order. However, after recording the reason for grant of such an order, though if any order is passed ex parte or without hearing to the principle of without giving the an opportunity to the respondent, then NCLT or NCLAT has to record the reason for grant of such an order and why it has chosen not to adhere to the principle of natural justice at that stage. So if we can explain in 2-3 line about the High Court decision is that High Court clearly had that the principle of natural justice has to be followed by the NCLT, though it is NCLT and NCLAT is not bound by the Code of Civil Procedure in 1908, but still they have to follow the principle of natural justice in general. If there is any special case where the situation requires that NCLAT or NCLT has to pass an ex parte judgment, then they have to record the reason for that. Next is Cushman and Wakefield India Private Limited versus Union of India. Basically, this case is related to the registered valuer regulations. This is not related a case where any regulation of IBBI has been referred. But since it's part of our syllabus, so we have to read it. So this case is basically related to a this case is basically related to the registered valuer and valuation rules, which is there was one clause in those rules that I am referring that clause. No partnership entity or a company shall be eligible to be a registered valuer if it has been set up for the object other than rendering professional or financial service. There is no issue till this line. If there is any company or partnership firm, it has a register. The requirement for registration is that it has the purpose. The main object of is there to render the professional service and financial service, including valuation service. And the issue was they started from this line, and that in case of a company, it is a subsidiary, joint venture, or associate of another body corporate. So in case of a company, it has not to be a subsidiary, joint venture, or associate of another company or a body corporate. So this clause has created a basically problem with the many companies. I think this Cushman and Wakefield was a very well established real estate consultant and valuer in those fields. So it was a subsidiary of a, I think the holding company was registered outside India, either in Germany or in some other country, and it was the subsidiary company of that company that was working in India as a Cushman and Wakefield India Private Limited. So in the present case, the council. So in the present case, the council on the behalf of petitioner submitted that the petitioner are engaged in the business of real estate consultancy service, including the provision of real estate valuation service. The petitioner, being a subsidiary of a reputed body corporate, is universally recognized as a lauded leader in providing the valuation service and enjoy a reputation beyond reproach both in India and abroad. So basically, the Cushman and Wakefield was a subsidiary of a MNC, and they are the leader in the real estate consulting and valuation services. So when these regulation comes, now the issue before the company is that they are they become ineligible to register as a registered valuer. So they file a writ petition before the High Court. The petitioner has over the years been instrumental in setting benchmark for high standard transparency and fairness with respect to the valuation service. So they argued that this regulation has impaired the right of petitioner to carry on trade and business, which is guaranteed by the Constitution of India, as it outset the petitioner from being a registered valuer merely on the ground of it being a subsidiary of a body corporate, which is patently discriminatory and arbitrary. So the contention or the argument of the appellant was that because these due to this regulation, a company which is a subsidiary of some other company has not been allowed to register as a registered valuer. So it is this has impaired the right of that company, which has been provided by the Constitution of India, right to trade and business. So the issue before the High Court is whether exclusion of a subsidiary company, joint venture or associate of other company for the purpose of eligibility for registration as a registered valuer is reasonable, or the regulation is the unconstitutional. This was the issue before the High Court. So High Court during the course of proceeding, High Court placed reliance on there was a judgment of Supreme Court in case of Dr. Haniraj L. Chulani versus Bar Council of Maharashtra. It was a decision that was given in 1996. Basically, in this case, there was Dr. Haniraj L. Chulani, who was a doctor in practicing. He completed his LLB and then applied for the registration as an advocate. So the Bar Council reject his application on the ground that he is practicing as a doctor. Until the time he surrender his license, medical practice license, he will not be allowed to register as a advocate. So the matter is reached before the Supreme Court, and in that case, the Supreme Court said that the State Bar Council of Maharashtra and the Goa was justified in refusing enrollment of the appellant as an advocate under the Advocate Act 1961, as he was also a medical practitioner who did not want to give up his medical practice but wanted to simultaneously practice law. The Supreme Court has as under the obligation to maintain the dignity and the purity of the profession and to punish erring member carrying with it the power to regulate entry into the profession with a view to ensure that only profession-oriented and service-oriented people to join the bar. So basically the opinion of the Supreme Court is that these professional body allow those professionals who are the professional-oriented, and they did not allow even at the entry point who are not professional-oriented or service-oriented. And these power are given to these bodies just to maintain the dignity and purity of the profession, and only the profession oriented person can join the profession. The role of the advocate is essentially different from the role of any other profession. And advocate said to be belong to a noble profession. So the High Court of the Supreme Court is of the view that only professional these type of regulation which are issued by the bodies who regulate the profession, the purpose of these regulation is to ensure the dignity and purity of the profession, and then to ensure that only profession oriented person can come to the profession who has the exclusive purpose to work in that domain. So High Court took the High Court in the put the reliance on that judgment of the Supreme Court, and the High Court noted that the objective and intention being behind laying down the impact rule is clearly to introduce higher standard of professionalism in the valuation industry, specifically in relation to valuation undertaken for the purpose of Companies Act and IBC. So the High Court dismissed the writ petition of the Cushman and Wakefield as it found as no merit could be found in the only ground argued by the petitioner. So he found no merit in the ground that being a subsidiary company, he is not be allowed to trade. Next case is related to the Uni Value Project Private Limited versus Union of India. In this case as well, one notification issued by the NCLT has been challenged. Basically, this is we can say recent case. On 12th of May 2020, the registrar of NCLT issued a notification that after 12th of May 2020, and basically registrar of NCLT at Principal Bench Delhi issued a order that if any new application under Section 7, there has to be a default record from IU. The application has to be filed along with the default record from information utility. If any application under Section 7 has been filed without any default record from the information utility, then that application will not be heard by the NCLT. And he also made one more thing has been ordered as well, that if any application is pending, is under process, then that application, that person or that financial creditor has to take the default record from IU and annex with that application before the next hearing. So the order was all concerned are directed to file default record from the IU along with the new petition being filed under IBC. Pending application also do the same before the next date of next hearing. So basically the impact of is that every financial creditor has to first file the record of default in the information utility, and then take the default record from IU, then he has to file the application. If there is no default has been updated in the IU by any bank or financial creditor, then he cannot file the application. So basically, what is the scope of power of the NCLT? So the decision of the High Court is that after analyzing the aforesaid judgment, the High Court concluded that while both NCLT and NCLAT have been conferred with the power to regulate their own procedure, such use of power is circumscribed and subject to inter alia the principle of natural justice, as well as the provision of Companies Act 2013 and IBC 2016. Therefore, the power of NCLT and NCLAT is limited by both by the principle of natural justice as well as the statutory provision and regulation framed under Companies Act and IBC Act. So this was the same decision, like similar comment or the observation which has been in the earlier decision of Siri Metallic. If a law is, so the High Court further observed that the High Court proceed to hold that the impugned order dated 12th May 2020 issued by the principal bench of NCLT is held to be ultra vires to the IBC 2016 and regulation thereunder and is accordingly struck down. So the financial creditor can now rely on either of the modes of the evidence at the hand to showcase a financial debt, that either a record of default from the IU or any other document as specified which showcase the existence of the financial debt. So now they have the option that either they can take the default record from IU or any other the document in their hand of the default. Basically, it has taken away the right of the financial creditor who has not registered their default or debt in the IU. Because if they have the document which support that that there is a they have given the extended the loan, they have given the loan, and the debtor corporate debtor has defaulted. But since their loan and the default is not registered with the IU, so it has taken away the right of those financial creditor to file the application under section 7 of the IBC. So accordingly, the High Court is the view that it is the ultra virus to the provision of the IBC. This circular issued by the NCLT. Jotun India Private Limited versus PSL Limited, High Court. Jotun, basically, Jotun India was the operational creditor of PSL Limited. PSL Limited, Jotun India was the operational creditor of PSL Limited. This case, the story starts early in 2015 when Jotun India has filed a petition in March 2015 under section 433 and 434 of the Companies Act for winding up of PSL Limited, claiming an outstanding sum of 7.25 crore with interest in respect of an unpaid invoice for goods supplied. So PSL Limited has not made the payment against the goods supplied, and Jotun India Limited has filed the petition under section 433 and 434 of Companies Act. In June 2015, the PSL Limited made a reference to BIFR. So in June 2015, the PSL has applied for the BIFR, made application to the BIFR and under Sikh Industries Companies Act 1985. So in December 2016, IBC came into the picture and there was a 180 days window was given. There was a, when IBC came into the force, there was a 180 days window was given that if there any case is pending under like BIFR or any petition is pending under 433 or 434 of Companies Act, the whole case can be shifted to the under IBC. So on in this window, in May 2017, PSL filed an application under section 10 of the IBC before NCLT within a window of 180 days. Since a separate application has been filed before the NCLT under IBC, so and one application was also going on before the under the that section 433 and 434 of Companies Act before the High Court. So there was two parallel application was there in this case. One is the under NCLT, section 10 of the NCLT, and another application was earlier filed in June 2015, in March 2015, under in before the company. That was application was also going on before the High Court. So what happened? The company judge of High Court stayed the proceeding under section 10 of the code before NCLT Ahmedabad. The non-speaking stay order was passed on July 2017 by the company judge. So there was two parallel applications. One was filed by the Jotun India Private Limited before the High Court for the winding of the PSL Limited. PSL Limited first filed a BIFR application. Then after IBC was in force, then he filed a section 10 application before the NCLT. So there was two applications. One was filed by the corporate debtor and one was filed by the operational creditor. So the the judge who was who are hearing the Companies Act application, he stayed the proceeding of the NCLT under Section 10. Section 10 proceeding, he made a stay on that application. He issued a non-speaking order. Stay order was passed by the company judge. So now when the matter was come to the higher bench of the High Court, whether the issue that whether the company court has any jurisdiction to stay the proceeding filed by a corporate debtor before the NCLT. So what High Court observed that? High Court observed that in case of a Supreme Court, in case of Madura Court Limited versus Modi Rubber Limited, the Supreme Court held that the provision of SICA is prevail over the Companies Act. And when the IBC come into the picture, then the provision of IBC will prevail over the provision of the Companies Act. So the High Court agreed that with the submission, the High Court agreed with the submission that the admission of a winding up petition by the jurisdictional High Court would not mean that NCLT either lose jurisdiction or cannot exercise jurisdiction in case of petition which is filed by the corporate debtor itself under Section 10 of the code. So High Court further elaborated that NCLT is not a court subordinate to the High Court. So High Court held that NCLT is not a court which is subordinate to the High Court, and hence as prohibited by the provision of Section 41 of B of the Specific Relief Act, and no junction can be granted by the High Court against a corporate debtor from the institution of the proceeding in NCLT. So High Court said that NCLT is not a subordinate court to the High Court, so he cannot provide any relief to the in the proceeding before the NCLT. So the company court does not have any jurisdiction to restrain NCLT proceeding. An order can be recalled if it is passed without jurisdiction. So High Court may refer that matter to that company bench of the High Court, that you have to recall your order that has been passed without the jurisdiction. Next case is of Deputy Director, the ED versus Axis Bank and others bank. So in this case, High Court dealt with 5 appeals under Section 4, which are filed under Section 42 of the PMLA against similar order of appellate tribunal constituted under PMLA. There are different 5 appeals which has been clubbed and heard in one go by the High Court. Appeal number 1, where the OD car was attached by the ED and Axis Bank claim or right over on the car on account of hypothecation. So the Audi car was attached by the ED and Axis Bank claimed that it has the right over the car because it has given a loan on the hypothecation of the car. In the second case, SBI has provided loan for purchase of some machinery on diagnostic security of immovable property in the name of the individual. The loan was not repaid and SBI obtained recovery certificate from the DRT. It was noticed that the invoice and receipt presented before were fabricated document and SBI lodged an FIR. Information was conveyed to the ED, and considering it a case of money laundering, ED attached the asset of the borrower and the guarantor, which were subject to the mortgage of SBI. So when SBI came to know that some invoice and receipt has been fabricated, so he referred the matter, he filed an FIR and referred the matter to the ED. Accordingly, ED attached those assets which has been mortgaged to the SBI. In the third case, IBBI has granted CC facility on the 6 property, including 2 soaps. Later, IBBI initiated SURFACI action, and in the meantime, ED has also tested those properties as well. In the case 4 as well, PNB has granted loan. So most of the bank are covered here in this case. PNB has granted credit facility against mortgage of 6 property by deposit of title deed. Loan were not paid and PNB started action against SFSI and also filed a case of fraud as the receipt and document were fabricated. What ED did, ED attached those property under PMLA. And then now in all the 5 appeals, what was the issue? Because bank were involved. So bank, there was basically loan was given by the banks on the hypothecation or mortgage of the properties. And also there was some fraud or the offense was also committed by the borrower. So accordingly, ED was involved and ED has also tested the properties. Now the issue arises that who has the right over the properties? Can bank sell those assets and recover the money? Because or the ED has the right because he has a test those property and matter is related to the matter is basically related to the fraud or the result of criminal activity. So basically in all the 5 appeal which has been clapped by the High Court, the issue was before the High Court, which High Court has to decide was whether RDDB Act, SARFAESI Act, IBC prevail over PMLA Act. That these act prevail, who act prevail with other, and whether the bona fide third party claimant has a legitimate right to proceed ahead with the enforcement of its claim. If there is a bona fide third party right, like bona fide right of any bank, then can he proceed with that right to enforce its claim, notwithstanding the order of attachment under PMLA. So High Court studied the PMLA Act and noted that under the PMLA, the expression proceed of crime constitute the core of the offense of money laundering. So what is money laundering? It has to be the proceed of crimes. And what is the crime? That is a result of criminal activity related to the schedule offense. So there are 3 schedules in which different type of offense has been specified or prescribed in PMLA Act. And if there is an activity which come under those offenses, it is then that has to be considered as proceed of crime. And to attest that property, the proceed of crime has to be result from the transaction involving that property. The eventual touchstone remains that the property attached or the to be confiscated must be such as involved in or used for the commission of the offense of money laundering. So High Court said that to attach a property, that property has to be either involved in or used for the commission of the offense of money laundering, which has been prescribed in the PMLA. So High Court said that the moratorium enforced in terms of Section 14 of the IBC cannot come in the way of statutory authority conferred by PMLA on the enforced officer for depriving a person of, even if it is a corporate debtor, of the proceed of crime. A view to the contrary, if taken, would defeat the objective of PMLA. So High Court said that if a contrary view is taken, then it would defeat the objective of PMLA by opening an escape route. High Court said that, like, if any person has made a committed a fraud, he has generated some asset with the proceed of crime. Now, if Section 4 IBC override the PMLA, then it will provide an escape route to that person. A view to contrary, if taken, would defeat the objective of PMLA by opening an escape route. After all, a person indulging in money laundering cannot be permitted to avail the proceed of crime to get a discharge for his civil liability towards his creditor for the simple reason such assets are not lawfully to claim. The court also said that these act like RDDB, SARFAESI, IBC, and PMLA court also examined the object and region of enactment of these act and noted that the object and region of enactment of 4 are distinct, each operating in different field. So there is no overlap. So High Court sum up that the objective of legislation in PMLA being distinct from the purpose of these the other three, like RDDB, surface and insolvency. These three, the latter cannot prevail over the former. So the provision of PMLA will prevail over the provision of these three legislation. There is no inconsistency. The purpose and the text and the context are different. The court thus rejected the argument of prevalence of said laws over the PMLA. So the High Court, the conclusion of the High Court is that the PMLA, RDDB, Surface I and IBC must coexist, each to be constructed and enforced in harmony, without one being in derogation of the other. With regard to the asset respecting which there is a material available to show, the same has to be derived or obtained as a result of criminal activity relating to the schedule offense, and consequently being proceed of crime within the mischief of PMLA. So harmonious construction has to be given in the light of circumstance of the case. So High Court said that these 4 acts has to be coexist, and a harmonious construction of the provision, harmonious construction has to be given to the provision of these act. Like if there is any asset which has been generated from the pursuit of crime, then the PMLA has a exclusive right over there. But if there is any asset which is not generated through the pursuit of crime, then these act can take the PMLA can take the back seat. So the observation of the High Court is that the harmonious construction has to be So High Court clearly mentioned that the harmonious construction has to be given in the light of circumstance of the case. So each case is different now. So in every the circumstance of each case has to be taken separately, and accordingly the harmonious construction has to be given, and it has to be seen that which act will take the back seat and which act will take the front seat. In the view of the court, the point number 2 concluded that the date or the period of commission of criminal activity, which is the basis of such action under PMLA, can be safely treated as cut-off date. So High Court said that we can take a cut-off date, like when the person started the criminal activity. The any asset generated before that will not be the proceed of crime, and the asset generated after that can be considered as proceed of crime. So this basically, this is a lengthy case. There are 5 appeal has been taken by the High Court. 5 different basically cases has been decided by the High Court in one go. All have the same type of circumstance. These cases also have the same type of background. Varsana Ispat Limited versus Deputy Director of Enforcement. The ED attached some property of Varsana Ispat Limited, the corporate debtor. ED has attached some property of the corporate debtor. When the matter, after the attachment of the property, the corporate debtor goes into the in IBC, and application has been admitted by the NCLT. For the IBC, the resolution professional has been appointed. Then the resolution professional filed an application before the NCLT that ED has attached some property, and without those properties, it is not possible for him to sell the corporate debtor as going concern. And he also take a stand that since the after the initiation of the CIRP, section 14 came into the force and a moratorium has been applicable, and now the ED does not have any right over the property of the corporate debtor. So the RP filed an application before the NCLT Kolkata bench for releasing the attachment of certain asset of the corporate debtor by Deputy Director of Enforcement. So basically, first the order ED has attached some asset. On going through the order of attachment, the A observed that attachment order was passed on 10th of July 2017 prior to the order of declaration of moratorium in the case in hand. So what AO noticed that the in ED has attached the asset much before the initiation of the CIRP. So learned counsel appearing on the behalf of appellant resolution professional submitted that section 14 of the IBC has an overriding effect on the provision of the PMLA. The reference was made to the section 238 of the IBC, which was submitted during the period of moratorium. The creditor and all the authorities causing any disruption in the CIRP cannot be allowed to do so. So he said that since the basically RP submitted that these assets are the important for the going concern of the corporate debtor, ED has attached them. Now section 238 and section 14 come into the picture, so that attachment has to be released. So what was the issue before the High Court is that NCLAT is that whether the provision of section 14 of IBC supersede PMLA, whether the attachment made by the ED much prior to the initiation of CIRP can be set aside by the AA. NCLAT noted that since section 14 is not applicable to the criminal proceeding or any penal action taken pursuant to the criminal proceeding or any act having essence of crime or crime proceeds, the object of PMLA is to prevent the money laundering and to provide the confiscation of property derived So the High Court NCLAT noticed that the PMLA provision relates to the proceed of crime. So High Court hold that section 14 of the IBC is not applicable to those proceeding. So High Court find the attachment were made by the ED much prior to the initiation of CIRP. Therefore, the RP cannot derive any advantage out of the section 14. So what NCLAT decided that held that since the attachment has been done by the ED much prior to the initiation of CIRP, so you cannot take the benefit of section 14 or 238, and so ED has the right on those assets. This case is Venus Recruiter Private Limited versus Union of India. This is a High Court case. Basically, in this case is related to the PUFE transaction, preference avoidance undervalued transaction. Basically, after the approval of resolution plan, when the resolution plan was approved, after that, RP came to know that some transaction came into the notice of the RP. And he filed an application with the AA for those transactions. So A allowed that application. A allowed this impediment. The party so impeded has challenged the A order before a single judge of the Delhi High Court. So the Delhi Court, now the Delhi High Court was considering the following question: whether the IBC, an application filed under section 43 for avoidance of preference transaction, can survive beyond the conclusion of the resolution process, and the role of RP in filing pursuing such application. Basically, resolution plan was approved. After that, the transaction was came into the notice of the RP. So he filed an application before the AA. AA allowed the application. but the aggrieved party challenged the application before the Delhi High Court. So the one question was before the High Court is that can the application can be survived beyond the conclusion of the resolution plan. So court observation is that RP cannot wear the hat of the former RP and pursue an advance avoidance application in respect of a preferential transaction after the hat of the corporate debtor has changed and it no longer remain a corporate debtor. So RP said that you are a former RP now. The court said that, High Court said that you are not a RP now, you are a former RP now. As a former RP, you cannot pursue an avoidance application in respect of any POF transaction. And also the corporate debtor has been changed. Now the new company has taken over the debtor. And further also, same has to be read in context of the fact that the resolution plan did not contain a provision which would permit the RP to continue to function for the specific purpose. Also, there is no provision in the resolution plan that RP can function after that resolution, after the approval of the resolution plan. So what principle has emerged from this case is that the principle that seemed to have emerged from this case is upon approval of a resolution plan by the AA, the RP become function officio and has no power to act on the behalf of the corporate debtor. Consequently, it become important for the resolution plan to contain specific provision to allow the RP or any other specified entity to continue prosecution of avoidance application. So if RP want to act after that, after the approved resolution plan, so he has some specific provision. He has to ensure some specific provision in the resolution plan. Next case is Kundan Care Product Limited versus Amit Gupta and others. Basically, in Supreme Court case, we have discussed a case Gujarat GUVNL versus Amit Gupta. Gujarat Urja Vidyut Nigam Limited GUVNL versus Amit Gupta, in which there was a issue of PPA, power purchasing agreement. Basically, this case is related to the same corporate debtor. Kundan Care was the successful resolution applicant of Stonefield Solar Gujarat Private Limited, and the resolution professional was the Amit Gupta, who was also a respondent in this case. This resolution plan of Kundan Care has been approved by the COC, and it was filed before the NCLAT. But since the PPA related to issue was going on before the Supreme Court, so there was a delay in the NCLT. In over the course of CIRP, the resolution plan was Kundan Care was the successful resolution applicant, came to be approved by the COC of the CD. Accordingly, an application has been filed with the NCLT seeking approval of the resolution plan. In that interim, due to pending proceeding before the Supreme Court, there was a delay in NCLT hearing the resolution plan because the proceeding related to the PPA was going on before the Supreme Court. So NCLT was not taking that case for hearing for that approval of resolution plan. So there was a delay in that case. So what the resolution applicant took a stand that now there was a huge delay in the approval of plan with the NCLT. So he seek the NCLT for the withdrawal of resolution plan on the basis that resolution plan has become commercially unviable and unfit for the implementation on account of delay in concluding the CIRP of the corporate debtor. So he took a stand that successful resolution applicant Kundan Care took a stand that there is a delay in approval of resolution plan. Due to this, resolution plan has now become the commercially unviable and unfit. So he should be allowed to withdraw its resolution plan. So what the decision of NCLT? NCLT reject that request of appellant to withdraw the resolution plan. So now after dismissal by the NCLT, the matter goes with the NCLAT. So what now the decision of NCLAT is that, so when the hearing of the in the NCLAT was going on, the appellant Kundan Care relied upon the judgment of NCLAT in the matter of COC of Metallist forging versus Deccan Value to argue that since the IBC does not compel specific performance of a resolution plan by an unwilling resolution applicant. So he took a stand that, Kundan Care took a stand that in one case of metallist forging, and NCLAT has decided that if there is an unwilling resolution applicant, a request for withdrawal of resolution plan by successful resolution applicant will have to be accepted. So in one case, NCLAT allowed a withdrawal of resolution plan because he said that IBC does not compel specific performance of a resolution plan by an unwilling resolution applicant. But the NCLAT took a different view in this case. NCLAT, while upholding the decision of NCLT, relied upon the judgment of COC of Educam Solution Limited. Basically, it was now the Supreme Court decision of Educam versus ABX, which is part of our syllabus as well, came into the picture, in which Supreme Court says that once the plan is approved by the COC, now it cannot be withdrawn, because in that case the scenario was similar. Educam Solution ABX Singapore PT Limited want to withdraw the resolution plan, and Supreme Court did not allow that. So the NCLAT, while upholding the decision of NCLT, relied upon the judgment of COC of Educam Solution Limited versus ABX, and held that in order to maintain the sanctity of resolution process, it become essential that the resolution plan of the appellant, which has been approved by the COC of the CD, is not permitted to be withdrawn. And it also held that NCLAT held that appellant cannot at an advanced stage into the hierarchy of corporate debtor seek any withdrawal of the resolution plan. But it allowed some wriggle out of its obligation. So it allowed some change. NCLAT allowed some change in the resolution plan, but NCLAT said that you can change or amend the resolution plan to some extent, but you cannot withdraw the resolution plan.
Sir, could you repeat this last sentence?
So NCLAT said that you cannot, because earlier NCLAT has given a decision in one case that if the resolution applicant is unwilling to pursue with the plan, that it can be allowed to withdraw. But after that decision, Supreme Court in case of Educam Solution said that resolution plan once approved by the COC cannot be withdrawn.
Yes.
This case is also part of our syllabus, Educam Solution versus ABX.
Yeah.
So based on that decision, NCLAT did not allow him to withdraw the resolution plan. But he said
and
that
wriggle out of its obligation.
Sorry?
And wriggle out of the obligations. That there is no mention of a modification of the plan.
Yeah, but that is what mentioned. I have not mentioned here. I am noticing. I am writing it. I will mention that.
Okay.
But there was some modification was allowed to make it the commercially viable.
Because by the language of serial number 3, it is clearly said withdrawal of resolution clause was not allowed.
Yes.
And the appellant was not able to wriggle out of its obligation.
Sudarshan Bhatt, the liquidator of ABG Shipyard Limited. Basically, this is a simple case. Basically, ABG Shipyard Limited was a very big company in the shipping business. The liquidation of the ABG shipping was was under process. Basically, it was in April 25th April 2019. The liquidation order was passed. So the thing was that there was a timeline of 15 days. Once the asset has to be sold by the liquidator, the successful bidder has to pay the amount within the 15 days. This was a clause in the IBBI regulation that the successful bidder in the bidder in the liquidation, in the when the bid is happening in the liquidation, the successful bidder has to pay the amount within 15 days. There was a 15 days time frame for the payment of consideration. After the 15 days time frame for payment of consideration after the conclusion of e-auction, after the highest bidder was shortlisted. But basically the size of the bidding was very high because it was a shipping company. So no one was ready. The liquidator has concluded the 4 round of bidding, but no person was coming, or no company was coming in and we agreed to pay the amount within 15 days. So later on, the liquidation was approved on 25th of July 2019. On 25th of July 2017, 25th of July 2019, the 15 days timeline was changed and made it to 90 days period to make the balance consideration. So 15 days time was too short. So the appropriate authority took the notice of that and introduced a 90 days time limit. They extend it to 90 days. So accordingly, the appellant filed an application with the AA, said that due to the benefit modification in the regulation, it has to be allowed the period of 19 days. Since the 90 days has been allowed by the IBBI, so in this case of ABG Shipyard, the same has to be allowed the 90 days timeline. But the NCLAT did not accept his application and said that the IBBI circular is have the prospective effect because it has been issued on 25th of July 2019. So any order of liquidation which is issued after 25th of July 2019 will come under this the purview of this circular, IBBI circular. So if there is any order of liquidation which has been issued passed before 25th of July, that will not come or in the purview of this circular. So when the matter come with an NCLAT, so NCLAT held that recognized that the replacement rule introduced as an amendment did not indicate that the regulation would only be implemented prospectively. It was an open-ended procedural law provision that made no claim that it would not apply to current liquidation proceeding on the date of replacement. So NCLAT said that though the circular has been issued on 25th of July, but it does not say that it will apply to only only liquidation proceeding which has been passed after the issue of circular. And it also the circular. So it is an open-ended procedural law provision that made no claim that it would apply to a current liquidation proceeding. It would not apply to a current liquidation proceeding. So thus the circular issued by the IBBI could not take away the benefit granted by amendment, and therefore amended clause 12 of the Schedule 1 to apply to the liquidation process, even though initiated before 25th of July 2019. So NCLAT allowed the liquidator of ABG Shipyard to go ahead with the 90 days time limit.
So Sanjay Singhal ji, can we take
Yes.
up rest of the cases some other day, or you want to continue? As you told, na, you have to go
Yes,
somewhere.
yes.
Mm-hmm.
Yeah, just last case. After that, we can.
Okay.
Rajneesh Jain versus Manoj Tiwari, IRP. Manoj Tiwari, IRP and others. This is an NCLAT case. Basically, the Manoj Tiwari, the respondent, was a partner, along with his partner, has given 80 lakh rupees at the rate of 18% to the corporate debtor. The corporate debtor was Jain Manufacturing India Private Limited, that was owned by Mr. Rajneesh Jain, who was the appellant in this case. So Mr. Manoj Tiwari has given 80 lakh at the interest of 18% per annum to the corporate debtor. when the CIRP application was of the corporate debtor, Jain Manufacturing was approved by the NCLT. So one IRP, Mr. Manoj Kumar Singh, the IRP was appointed. So the Mr. Manoj Tiwari submitted his claim in Form C as financial creditor, and IRP admitted that claim of the respondent as financial creditor. And he included his name in the list of the COC, the IRP. But after the IRP, the IRP has been changed and one new RP has been appointed, Mr. Anupam Tiwari. So Mr. Anupam Tiwari, now what Mr. Anupam Tiwari did, Mr. Anupam Tiwari took the opinion of the two experts and he changed the status of Mr. Manoj Tiwari from the financial creditor to operational creditor. When the then Mr. Manoj Tiwari applied to the NCLT. So so what happened when the application goes to the before the NCLT? So Mr. Anupam Tiwari organized a meeting of the COC, fourth meeting, and the COC approved the status of Mr. Manoj Tiwari as a financial creditor. So initially IRP approved Manoj Tiwari as a financial creditor. Mr. Anupam Tiwari, who was RP, changed his creditor from financial creditor to operational creditor. Then when he saw that the matter has gone before the NCLT, so what he did, he organized a meeting of a COC, and in the COC meeting, the COC voted in favor of that the respondent Mr. Manoj Tiwari has to be treated as the financial creditor. So the issue before is that does the COC has any power to decide that who is the financial creditor and who is the operational creditor? Because when the matter goes before the NCLAT, then COC decided. RP hold a meeting of COC, and in that meeting it has been decided. It was clear from the record of the meeting that COC decided that he is the financial creditor. The NCLAT noted that IBC is a complete code in itself. Further, the power and duties of CAC are specifically laid down in the section 828 of the IBC, specify the stage where the RP had to obtain prior approval of the COC. The NCLAT observed that the act of the resolution professional to refer the matter to the COC to determine whether the claim of respondent fall in the category of OC or FC is beyond the subject matter listed in the section 28 of the IBC. So the NCLAT has the NCLAT decision is that COC does not have any power to decide that any creditor is FC or OC. So the decision is COC was not empowered to adjudicate the issue that has been cropped up in the present case, whether the Messrs. BV and trader is a FC or OC. Such adjudication is beyond the scope of consideration of COC. And RP is also added to reclassifying the status of a creditor from FC to OC based upon the alleged expert opinion, despite that A took a contrary view. So decision of A upheld. However, the reliance on decision of COC set aside. Basically, that when the matter referred to the NCA or the NCLT, NCLT said that the Mr. Manoj Tiwari is a financial creditor, and he also said that since the COC has decided that Mr. Manoj Tiwari is a financial creditor, so he does not challenge the wisdom of the COC and NCLT. Subsequently, the NCLT in its impugned order in August 20 observed that the COC voted in favor of respondent to be treated as financial creditor. Further, the appellant and RP has no locus standi, no locus to challenge the commercial wisdom of the COC. So this was decided by the NCLT. So NCLAT said that though the decision of A is upheld because he said that that person is the financial creditor, but his reliance on the decision of COC in regard to that who is the financial creditor and who is not is set aside. So this is I think we have covered around 50 cases, around 10-12 cases is left. 8-9 cases of NCLT and 2-3 cases of NCLAT, and most of the cases we have covered. So if
Thank you very much, CA Sanjay Singhal ji, for a beautiful deliberation. In case participants have any questions, they can ask, or otherwise, yes, please.
Sir, in this case class, sir, the type of questions expected in the examination.
Actually, what we will do is, when we complete these case laws, no, so we will organize an MCQ session.
Okay.
And basically, we will be concentrating in that session on what are the keywords used in a particular case. What is basically discussed, whether powers of COC or power of resolution professional or any circular or any amendment. So we will try to classify it accordingly, and we will formulate an MCQ based on the type of questions which are being asked in the exam recently. In case you have got some experience or you know certain good questions, you can also post it in the group. Otherwise, once we are over with this discussion on case laws, so we will have an MCQ on some Sunday, and that information will be posted in the group.
Thank you, sir. Thank you.
So thank you very much, all the participants. So we are ending the session now with permission of CS Sanjay Singhal ji.
Okay.
Okay, sir.